appeal in the matter of Safi and Secretary of State for the Home Department.
Yes, Mr. Keith.
Please, Your Lordship. I appear on behalf of the Appellant Secretary of State in this matter. My learned friend Mr. Symes and Ms. Sardar appear on behalf of the Respondent. Can I first check that the panel have the requisite bundles? There should be
One call, one supplementary,
one call, one
authorities.
supplementary, one authorities, and the updated skeletons.
And the skeleton. Oh,
As in with references rather than updated.
the only skeleton I have from your side, yours, is from 2024, pages 32 to 41. And Mr. Symes is of September 2025.
Okay. Well, I mean, we've both updated those skeletons with brackets for the cross-references bundle. So whilst it would be helpful, I don't think it's fatal to any.
It's no. Well, I just have what was in the core bundle. My lady has the advantage of me. Respondent's replacement skeleton.
Which is the same that has references.
Oh, I see. Yes,
So
that's Mr. Symes's with bundle references added.
Yes.
Well, if there are any hard copies which anyone can spare of the up-to-date versions, that would be.
Let me just turn my back. I'm not sure we have any hard copies. Unfortunately, no hard copies, my lord. I can try and get some to you.
Could you? Yes, I'll have them fetched.
Sorry, my lord.
Right. Okay.
The day of electronics means that carry as few papers as possible.
Right.
Certainly. So, my lord, this is my appeal on behalf of the Secretary of State. It seems that the facts are agreed between the parties essentially, and so the questions for this court are, in my submission, twofold. Firstly, whether this court should interfere with a decision of the First-tier Tribunal, and then secondly, whether linked to that is whether the reasoning by the First-tier Tribunal was sufficient to make the ruling it did, or whether, as my submission is that the First-tier Tribunal ruling is deficient in its reasonings and therefore should be remitted to be remade.
That's not an express ground of appeal, though, is it? That the reasoning was insufficient. The ground of appeal is just that. You two were wrong to decide that there was no error of law.
Yes, my lady. The precisely pleaded grounds are in the bundle. The pleaded ground is that the upper tribunal was wrong to not decide there was an error of law, but in practice.
And then it misdirected itself about general risk and level of poverty, etc.
Yes.
And didn't use risks which were specific to the respondent.
Yes.
Yes.
So, my lady, I was going to the first thing that there's two. I was going to start with some of the authorities on where this court is reluctant to interfere with decisions of the First-tier Tribunal, and explain why I say that this is a case in which this court should interfere with the First-tier Tribunal's decision, and then go to the just to set the framework very briefly, and then go to the matter at issue, which is the application of the Unten case and whether there's sufficient reasoning for destitution, etc., to be shown in the First-tier Tribunal's judgment.
Right. Thank you.
In answer to my lady's question, it's my submission that it's for this court to examine the reasoning of the First-tier Tribunal per paragraph 52 of Yeltsin.
Yeah.
Mm-hmm.
We're more interested in what the First-tier Tribunal said or didn't say than what the upper tribunal said or didn't say.
Yes, and both parties have not really addressed the upper tribunal in any respect, other than to note that they refuse to find an error of law.
Could we, just before you embark, return to the point made by my lady? I'm looking at the grounds of appeal, or indeed the ground of appeal, which is page
29, I think.
30.
Yes.
In, and that identifies various forms of misdirection, which of course we will consider. But where in that do you place inadequacy of reasoning?
My lord, it's in my submission. It's one and the same thing, in that the real criticism of the First-tier Tribunal judgment is that we can't tell whether the law has been applied correctly or not because there's not sufficient reasoning. And if that's my the question.
Well, it's not what it says. I mean, to a degree, one has to operate on some form of tramlines or system when considering an appeal of this kind. And if somebody who hadn't read any of the FTT judgment came in and just read your paragraph 8, then they'd think that this was a competent judgment, which had in your submission a number of mistakes of principle in it. It isn't the sort of pleading that one sees where one is saying, well, this wasn't a competent judgment. I'm just putting that for your consideration, because we have to be alert that having advanced one specific ground, you don't then just use that as a Trojan horse to take aim at anything and everything. Appreciate you made that as a ground of appeal to the upper tribunal, but you didn't make that, so far as I can see, as a specific ground of appeal on this second appeal. It may not matter, I don't know, but I want to give you the opportunity to help us.
Can I throw into the pool that there are two versions of your grounds of appeal document. The one which begins at page 29 and the one which begins at page 46, which is rather fuller. You do say a bit more in page 46, although it's the earlier document. You set out your complaints about the FTT judgment in slightly more detail.
Yes, I follow that you had these grounds to the upper tribunal.
No, I think 46 is in the Court of Appeal.
Well, it's an application to the upper tribunal for permission to appeal to us.
So that I have to.
Oh, I see, yes.
And so
Yes,
strictly they aren't the grounds that are before us.
no, the grounds that before this court are the ones at 20.
Yeah.
Yes.
They were. I mean, I of course accept that those are the grounds that I put forward, and that's what I'm going to argue today. And perhaps it's my expression that has improperly tried to broaden my palette rather than stick to the specifics. So I shall try my very best to stick to what I've
Would you mind if we just pause on
course.
on this document again, because I don't want to. But again, there's one ground.
So, my lord, my understanding is that the skeleton argument that you have was put in at the same time. The grounds and the skeleton were submitted to the Court of Appeal in the same application.
Thank you.
And I don't. If I have attempted to broaden the definition, then I don't seek to. Lack of precision in dealing with this particular section. Obviously, the court is very familiar with the authorities as set out by my learned friends in relation to not interfering with the First-tier Tribunal decision. I am, of course, happy to take the court through those, but it's really, in my submission, contained in the Yalcin judgment, and I'm very happy to take the court through them, or go really straight to the meat of it, which is the what I say is the
Sorry,
misdirection.
Mr. Keith, I may be getting old and deaf as well as old and grumpy, but you are dropping your voice quite regularly.
My apologies, my lord. I'm happy to take the court through all the authorities in relation to the interfering or not interfering with the First-tier Tribunal decision, which my learned friends have cited in their skeleton argument, if the court would be assisted by that. But my submission is essentially that it's all contained within the Yalcin decision of the Court of Appeal.
All right, well, just show us the paragraph or two.
Certainly. So, it's paragraph 50 of Yalcin, which is at pages 344 to 345 of the bundle, of the authorities bundle. Yes, 344. Where Lord Justice Underhill cites Lord Hamlin in H.A. Iraq from the Supreme Court,
yes,
and sets out the principles of where this court might consider interfering with the First-tier Tribunal judgment, and where this court should shy away from doing so.
yes.
And obviously, I accept that this court is reluctant to interfere with a First-tier Tribunal decision, given that it is made by an expert tribunal, except in circumstances where it can be demonstrated that there is an error of law that was not properly ruled upon. And so my submission is that the principles are contained in paragraphs 50 and 51 of Yalcin in terms of the interference or non-interference with what it is, with the decision of the First-tier Tribunal.
Yes.
I also wanted to mention one other authority. So there is a trend, as my learned friend has pointed out, in skeleton and a desire, I understand, from the Lady Chief Justice and the President of the Tribunals for decisions to be concise and easy to understand for lay individuals. And to that end, again, the Court of Appeal shies away from criticising the First-tier Tribunal where it can. But I wanted to take you just briefly to what is said in TC Zimbabwe, which is at paragraph 61 of TC Zimbabwe, page 313. To the heading, which is structured, issues-based, concise decision-making. Obviously, the facts of T Zimbabwe are different, but this sets out what I understand the Courts and Tribunal Service to be trying to achieve, which is enough reasoning for everybody to understand the reasons given, but not reams and reams of decision making or facts. So those, in my submission, are the two authorities that I rely on.
Yes.
And in my submission, my learned friend has cited numerous other authorities which follow the same pattern. I'm sure he'll take you to those if he thinks that they materially change the position. So, I'm just going to bring my grounds of appeal back so I don't go off piece this week. So it's my submission, as I put in the grounds, that the key aspect of this case is the FTT misdirected itself in relation to destitution by equating the evidence of a generalised situation of poverty to a situation that applied to this respondent. And did not apply properly the test in ante, which if the First-tier Tribunal had applied that correctly, would have come to a different conclusion. Before I go to the reasoning, I'd like to just take you very briefly to ante, to the paragraph that I say is the key to the test in that case.
Intense suffering.
Yes. Your Lordship has it. So it's, I can, if you want to turn it up, it's at ante paragraph 136, page 298 of the authorities bundle. He says, so 296.
And that was paragraph.
Paragraph 136, my lady.
Thank you.
Beginning on the facts of this particular case. And it's the first half of that paragraph. So on the facts of this particular case, however, it is not. We are not satisfied that it is reasonably likely that MAA will find himself living in inhuman or degrading circumstances such that his life expectancy will be significantly reduced, or that he will experience intense suffering of the kind envisaged by the jurisprudence. And so it's that phrase, the intense suffering, the Lord Justice Bean has pointed out, is what we rely on as the test that should have been applied in this case and wasn't. And from there, my Lord, I would take you to the First-tier Tribunal decision, which is the core bundle. I'm going to go to paragraph 40, which is page 73 and 74 of the core bundle. Where the first-tier tribunals, so this is paragraph 40. I also accept that he's at particular risk of destitution. The expert evidence is that 98% of the population are in poverty. He will have extreme difficulties in finding accommodation, healthcare, and employment. I also take into account relevant case law such as Ante and AM Zimbabwe, which stated and then quotes the judgment.
How do you say the tribunal should go about considering the position of somebody who left the country as a young person and who, I think I'm right in saying, was not said to have any particular links remaining in the country in light of family circumstances and the distance of time? I mean, where you have somebody who is being considered for deportation, let's say 15 years later, who started as a child and is now an adult, what would a valid paragraph of that kind, paragraph 40, contain in your submission?
So the first-tier tribunal judge says, I also accept that he is particular risk of destitution. In my submission, and then equates, or seems to equate, the generalised background evidence to say, well, therefore he will be at risk of destitution.
Well, he gives examples such as accommodation, healthcare and employment as being instances that might be relevant to his economic status. I can see where somebody has recently left and there is a situation that one can envisage, namely that in town X or village Y, this situation to which he will return exists, and there is reason to believe that his situation can therefore be predicted. But in a case of this sort, is that exercise possible, or does one fall back on the best available general data?
So, my lord, think on my feet. My submission on that point is that any fact-finding tribunal has to look at the background evidence. The first thing to look at is the macro level in my submissions. You look at the generalised poverty level and the human rights situation, the rule of law situation in a particular country, and that is obviously the background that you're looking at, be that from the CPIN or from expert evidence. But unless that evidence is so overwhelming that it is impossible because there's a war on, or because there is persecution of a particular religious minority, for instance, that an individual cannot be returned there. In my submission, the position where there is extreme poverty in the country is not in and of itself enough to bar removal. So that's the macro level, and then in my submission, then a fact-finding tribunal, be that the Home Office or the First-tier Tribunal, or whichever tribunal is making the decision, then has to go into the facts of the case in terms of the individual and give reasons as to why they are at specific risk over and above the general problems in that country.
Well, that was really my question. How does one, in a case of this sort, become more specific? I mean, the appellant was before the First-tier Tribunal and available to be questioned about, well, you can go to village Y or you can go to town X and find yourself a job, get yourself a roof over your head. But that doesn't seem to have happened.
No, my lord, and I would submit that's probably an artificial distinction to make, because he's not going to know whether he can go to a village.
Well, that's why I'm asking this question,
So,
precisely because he's not going to know. So what case does he have to meet in order to show destitution? Does he have to say, here is my, if I was sent back, then I think I would go here and I would try to do that. I would then, if I couldn't do that, then I'd try to do this. What are we expecting is really my question. It's an open-ended question.
no, well, and not an easy question to answer, my lord. My submission would be that the fact-finding tribunal has to look at the characteristics of the individual: age, sex, sexuality, religion, health, mental health, any of those particular characteristics that might be relevant, might be different from a normal, healthy individual or of a similar age, and say, is this person at more risk than the general population of an Article 3 breach? Obviously, the evidence is that if 98% of the population are in poverty, that him returning to Afghanistan is almost certain to result in him living in poverty. To state the obvious, but that obviously what it is. But that, in my submission, isn't enough to meet the higher threshold in ante, which is the intense suffering. So nobody would wish anybody to live in poverty or to be returned to a country where they do live in poverty, but the test is of a much higher order of the intense suffering, such as for instance, the healthcare cases, the N&D cases and Popiashvili, where to not be removed on health grounds, you have to meet a very, very high test of intense suffering, and that has sort of been, I think, read over into ante, and so that's where we are today. May have been where we've been for a long time, but it's more explicit that that's where the threshold is. And I agree, it is not an easy thing for a fact-finding tribunal sat in the United Kingdom to make an assessment of a foreign jurisdiction, but that is the job of the First-tier Tribunal. Looking at the country policy and information note, looking at the evidence provided by the experts, and looking at the particular risks of the particular individual. And my real concern about, or my real submission about this is that the judge hasn't gone beyond the macro. That they have just looked at the extreme poverty and said, well, that means that he's at risk of having problems getting accommodation, healthcare, and employment. But those are, in my submission, functions of living in poverty.
I don't know whether you also say, but you might, I suppose, say he starts in paragraph 40 saying, I also accept that he's at particular risk. So I might say that he is focusing on the individual and not the macro. But then he goes on, he will have extreme difficulties in finding accommodation, healthcare and employment, which also may be based on individual circumstances, which is already considered the position of this person. But then presumably you would still say, although he has recited ante, etc., and the test in ante, he has not sewn those together in order to say, because of his personal situation, he is a particular risk of destitution, and that will lead to intense suffering, etc.
My lady, yes.
Can you say that?
Yes, and to try and sew together your ladyship's question and my Lord Justice Jackson's proposition, what's missing is a sentence or a long sentence explaining why he's at particular risk. What particular characteristics put him at particular risk? The conclusion might be the same, but there's no link between saying I also accept he was at particular risk of destitution to the meeting of the ante-test. And so that's where I say that the reasoning falls down. Because it's that is required to meet the additional threshold over and above the macro analysis of very poor living conditions. I accept it's not an easy task for any tribunal, any judge to make that decision. But the test is very high, and in my submission, the judge has not reasoned why it is met. Because they haven't applied, although the judge has written out the test, they haven't actually gone on to say why that intense suffering threshold is met. Simply that there are a number of factors that taken all together do breach Article 3.
Well, he does in 41 stitch everything together. Unchallenged expert evidence, that probably refers to westernisation and possibly re-trafficking, along with his particular vulnerabilities, health, and as a victim of trafficking. I find he is at real risk of such material deprivation and destitution as to justify raising Article 3 as a block to deportation. You say, I think, that there was nothing remarkable about his health. You haven't addressed us yet about trafficking, but presumably you will, as it goes both to risk of ill treatment on return, according to this paragraph, risk of deprivation and destitution on return.
My Lord, my submission is that yes, that doesn't fully reason the issues, that there is nothing remarkable about this particular respondent or specifically vulnerable, such that he meets the article the particular Article 3 threshold.
Could you just help about the basis for the original refusal letter of the 2nd of April 2019, would it be convenient if you just helped us as to how that decision fits into what the tribunals were dealing with? We have it at 75. I just would welcome help as to the extent to which this decision, which is dealing with very compelling circumstances and matters of that kind, overlaps with the Article 3 issue with which we're now concerned. I think it might usefully start at about page 87.
We'll just turn it up.
On 87 and 88, you see the seems to be the heart of the decision, but you will know.
My lord, my reading of that section has always been, I don't want to make this wrong, is that is, as titled at page 85, an assessment of the very compelling circumstances, so an assessment of that issue rather than the Article 3 issue.
Right, so where in this are we seeing an Article 3 determination apart from in relation to health?
There is none.
Right. Because his case, see page 84, was that he didn't have any family left, didn't speak the language, etc.
And my lord, again, I don't want to conflate, unfortunately, because of the way the system is set up, they're considered slightly in silos. But the assessment of very compelling circumstances under Article 8 is done by reference to, your lordship mentioned, being able to go to village X or village Y is in relation to relocation or internal relocation or protection from a particular act as in asylum. And the very compelling circumstances goes to Article 8, whether somebody has over and above that. But the First-tier Tribunal appeal, and I honestly don't know how they quite got from the decision for the Home Office to the decision of the First-tier Tribunal. The bit in the middle is not within my grasp. The facts before the First-tier Tribunal were, well, in fact, there are many more Article 3 issues that you need to look at. And in particular, you need to look at the risk of destitution, risk of re-trafficking, in combination with his health. So I suspect it was a...
By the time it got to the FTT, the issues in dispute included both Articles 2 and 3.
Yes.
So we don't necessarily find everything that the Home Office might have wanted to say about Article 3 in the original decision letter, because things have moved on.
No, precisely, my lord. The Home Office have not addressed destitution, have not addressed the re-trafficking issue.
Thank you.
And unfortunately, my lord, as you're well aware, me standing here several years later in the Court of Appeal, we have a completely different set of facts, or not a set of facts, but a completely different view of the case than was at the time. And there was a hearing at the First-tier Tribunal, and the Home Office presenting officer did accept some aspects of the case. And I'm always at pains to point out that I can't go behind that in this court, and I don't seek to, even if it doesn't necessarily assist my.
Well, I'm sure we're going to come at some point to westernisation. There's 150 pages of experts' reports in the bundle. The FTT decision, brief as it is, does make the point that the Home Office presenting officer was expressly asked, do you want to cross-examine on any aspects of what it's mainly Mr. Foxley says about westernisation, and said no. Do you accept that you're then stuck with everything that Mr. Foxley or Dr. Panjwani said?
Through gritted teeth, my lord, yes, I am stuck with that. But what I would say is that even on the evidence that was presented by the experts, it was not clear that the Article 3 test is met. So there is evidence of westernisation, there is a background to that again, but there is not, in my submission, even if the expert evidence is accepted, enough without proper reasoning as to why the Article 3 threshold is met in this case. And I think I've set out some of those paragraphs in my skeleton.
Is there a distinction between, even if those reports were accepted at their highest, Article 3 could not be met, and the FTT doesn't explain, with reference to those reports, why it is met? Which of those or both are you submitting?
My lord, both, but sequentially. So, firstly, the expert reports, I accept, give background evidence to westernisation, so they give the macro picture, but in my submission, they do not, in and of themselves, reach Article 3 for this appellant, or for this respondent, or as a general proposition. That doesn't mean that the First-tier Tribunal weren't allowed to take into account what they said, given that they were unchallenged. But in my submission, given that those reports didn't expressly say that the Article 3 threshold was met, that it was open to the judge to then go on to analyse those reports, to link it to the individual, to say, and this is why the Article 3 threshold isn't met. I've taken into account the background evidence, and that's why there is intense suffering, or like a real risk of intense suffering. And so yeah, so my submission is firstly that in and of themselves they don't meet it, and it was open to the judge to use them and link them and make a decision, but there isn't that link, and there isn't a proper application of the test in ante of the intense suffering.
Takes us back to paragraphs 39 to 41 of the FDT decision, doesn't it?
Yes.
And whether there is enough in those paragraphs or not.
I mean, my lady, that is ultimately the uphill and down dale is 39 to 41. Is that my submission is that those paragraphs are not sufficient reasoning to meet the Article 3 test.
38.
Sorry. Don't want to.
Yeah.
Yes.
Just to be, I agree with you, one doesn't want to pore too much over individual matters, but just want to understand exactly what your submission is in relation to the expert evidence. I understand that you say that the expert evidence does not require the tribunal to find that the Article 3 threshold is met for this individual. Are you going further and saying that it doesn't permit the tribunal to reach that conclusion?
I'm not sure. I'm not sure. I wouldn't use the word permit, my lord, but that would be, I suppose, what I would characterise it as is. It is background evidence, so it gives the the overall picture of the country situation. And with analysis of the individual case statistics, it can be taken into account, and it will prove one way or the other, well, it may show one way or the other that the Article 3 threshold is met.
Well, that would mean that it didn't, as you've said before, of itself permit a conclusion.
Yes. Sorry, my lord, I may be
No,
going around in circles. But, but because, and in my submission, and again, it would be most likely that if an expert did say, in my opinion, this particular individual meets the Article 3 threshold, then of course they would have to be cross-examined. If that was accepted, then that would be fatal to my case. The experts have been, I mean, they are known experts. They're very careful about how they put their case forward. But they don't go that far in my submission. And so in order for the Article 3 threshold to be properly met, the judge was required to take into account significantly more individual characteristics of the respondent and explain why those particular characteristics met the intense suffering threshold in the context of the expert reports and the CPIN and the general country situation. My lady, I'm not. Is there anything else I can insist on in relation to that issue? Otherwise, I was going to go to re-trafficking.
Right. Do that.
So on the re-trafficking issue, it's my submission that the conclusion by Dr. Panjwani, which is contained in the supplementary bundle, pages 78 and 79. Slightly difficult because obviously Dr. Panjwani is not a lawyer. He's not providing a judicial decision. He applies the test, and the test he applies is plausibility, which is the test in an asylum case, but not necessarily, but not in an Article 3 case. And so I don't propose to read out his conclusions on re-trafficking, but they're contained at pages 78 and 79.
I thought they were contained at the end of the report, a passage cited by Mr. Symes, page 99.
My lord, that's his conclusions. The reasoning is 78, 79, which I put in.
High risk of being re-trafficked.
So, my submission on this is that Dr. Panjwani uses the phrase, I accept he uses the phrase high risk. He also uses the phrase more than a plausible risk of persecution, as in an asylum analysis rather than an Article 3 analysis. but the First-tier Tribunal doesn't analyse why that conclusion therefore reaches the Article 3 threshold. And that may be, because the First-tier Tribunal judge has wrapped the different factors together in Article 3, which was open for the judge to do. And I accept I can't, unfortunately, I can't go behind the acceptance by the Home Office presenting officer of the First-tier Tribunal of that expert report. Sorry, sorry, my lord. I can't go behind the Home Office presenting officer in the First-tier Tribunal accepting those reports.
And I think earlier you said, when you were explaining the structure of this, that the reports provide a generalised approach, information about Afghanistan and the various risks and circumstances there. And then it was for the FTT judge to use that as a background, a landscape, in order then to look at the individual and his vulnerabilities, and I use that generally,
Certainly not.
and to decide therefore whether the Article 3 threshold was met. But when I look, for example, at page 79, and there are a number of examples, paragraph 7.2 of Dr. Panjani, he's actually being specific about Mr. Safi. Therefore, the last 3 lines of 7.2, therefore, if Mr. Safi were removed to Afghanistan, this is having set out all the information about what's going on, it's highly likely he would be vulnerable to being trafficked, etc. And then that is reiterated, and it's the same trajectory that Dr. Panjwani is taking in those final conclusion paragraphs. And I'm just looking at randomly in paragraph 90, page 99, paragraph 11.13. Mr. Safi arrived in this country clandestinely, etc. According to my professional expertise and research, there's a plausible risk of persecution of Mr. Safi. So when these paragraphs, or some of them, are referred to in the judgment of the FTT judge, he is referring to specifics rather than generalisations.
My lady, yes, he's well, taking the expert reports and using them as evidence to decide a case one way or the other, including
It isn't a case that the just dipping in to Dr. Panjwani's report that it's purely landscape. It's not saying this is a difficult regime. There are all these different things going on. Full stop. It is making comments in his expert capacity in relation to what, in the light of that landscape, would be the effect upon this respondent.
My lady, yes, and
I'm sorry, that's just not how I understood what you said.
no, and
so I just
perhaps I
wanted to
was
clarify.
oversimplifying the process, for which I apologise. I suppose I was trying to compartmentalise destitution, and the problem with compartmentalising one thing from the other is it doesn't always quite fit, because Dr. Panjwani is obviously dealing with re-trafficking, whereas Mr. Foxley is dealing more with the destitution issue. But I accept that the expert, Dr. Panjwani, gives an expert opinion.
Yeah.
So that expert opinion is plausibility in my submission, not a...
It's the difference. It's difference between the role of the expert and the role of the court.
Precisely, my lady. And we then go back to whether, well, to my submission, that the judge hasn't properly applied that test.
Thank you.
I ought to know, but I don't. Is there a procedure in the FTT under which the Home Office could have said if the experts' reports are going to be relied on, we want either or both of them to attend for cross-examination?
My lord, yes. I honestly can't remember the provision. If I can turn my back, I might be able to tell you the precise provision.
Well, if somebody can
But
give me chapter and verse, but in due course. But there is such.
In short, the adversarial process, the appellant, the migrant puts in their appeal with their expert reports and their witness evidence, and then it's for the Home Office to say, I want to cross-examine X, Y, or Z, or for the individual to call those individuals for cross-examination.
And it's commonly seen in country guidance cases that a grand selection of experts turn up and they give all evidence and they're cross-examined. Less commonly in non-country guidance case, but the provision is there anyway.
It is. It's
Yes.
well, treat this with caution. Well, I'm in the property chamber rules, but I can't imagine it's different anywhere else. Rule 19. You can get experts to
Mr.
provide
Symes
reports
or
and-
Miss Sada or can give us.
We'll
chapter
find the
and
right
verse
one.
later on.
Yes.
Certainly, but yeah, the experts are routinely called in the first tier. Well,
Yeah.
often called in the first-tier tribunal to give evidence, and are often challenged by the Home Office. Which is why, to be fair to the first-tier tribunal judge, they say, well, the Home Office presenting officer accept these reports.
Yeah.
I mean, there are situations, just to mirror that, there are some situations in which the Home Office might say, well, I don't accept the conclusions of a particular expert, but I don't require you to call them because I'm going to argue that in spite of their conclusion, they don't meet the particular legal test. But that's not this case.
It's not very difficult to see what questions could have been put, for example, to Dr. Panjwani. You set out in section 7 a great deal about the general situation, not challenging that, but why do you say in 7.2 that this places the appellant at particular risk? Anyway, that wasn't done.
My lord, no, it wasn't done.
And the same in relation to 1113 and 1114.
Yeah. All right, where do we go next?
My lord, just to sort of round everything off, I've mentioned a paragraph 14 of my skeleton that in my submission that the healthcare issue goes nowhere. He does have some mental health issues, mild depressive disorder and PTSD, but there is no separate health aspect considered in the Article 3 claim. It may be that it seems that health may have been taken into account in the overall round of the Article 3 assessment. But for the reasons I've already gone through, it's my submission that the test was not met and was not reasoned or explained why the test was met. Might I just turn my back for a moment?
Fastest direction from 2024.
I've got nothing else to add apart from to say that we've just checked the first-tier tribunal rules. It's Rule 15 of the first-tier tribunal
Thank you.
rules that allows, and I can send that to your clerk, that allows witnesses to be summoned to cross-examination.
My lord has just whispered in my ear that there's a practice direction which says that experts' reports should be limited to 20 pages, but I don't think that's not a point which can be taken against anyone at this stage, but there is some point to it.
So I think It may even change to be shorter, I think. It may even now be without leave of the court. But yes, they are now trying to be strict on.
Re-trafficking. What do you say about? What do you say, if anything, about paragraph 38 of the FTT decision?
Turn it up again, my lord. There's not much more I can say, my lord, than is in my skeleton in relation to paragraph 38. Namely that there wasn't whilst there was the expert reports, there wasn't a proper analysis of the of why there was a risk of trafficking to this particular individual, given that the trafficking was so long ago. Him being a child when he was trafficked, and now returning as an adult.
And the single competent authority decision was that he had been trafficked.
Yes.
And the expert evidence you say is that it's a common phenomenon, but they don't tie it into him in particular.
My lord, yes.
Right.
So, in the same way, a generalised position is taken rather than analysis by the First-tier Tribunal. That I accept what is said by Dr. Pashwani doesn't necessarily support my submission.
Thank you, Mr. Keith. Mr. Symes.
Thanks very much. Well, you have the advantage of my skeleton argument in the annotated version.
Yes.
Even more efforts have been made to get it to you in the course of my learned friend submissions. But in any event, although I'm generally speaking going to follow it, I'm going to use it as a background reference point more than anything else. My oral submissions, taking on board observations made by the panel today, are going to follow this format. I'll be making 5 broad points. First broad point is the procedure that was adopted in this appeal. Second broad point is the expert evidence, which I'm going to give you a brief tour of, but it will be brief, which is important because of the way that the proceedings went below. My third point, only then to delve into these fairly short and concise paragraphs of the First-tier Tribunal, just to put in context where the FTT was coming from when it made its findings, which we've already looked at in some depth, the paragraphs especially 39 to 41. My fourth point will be to look at the law, the general law of reasons, this will be super fast, and then the First-tier Tribunal's own regime, which we'll look at in slightly more detail, but that won't take long either. And my fifth and final point will be to look at what happened with the upper tribunal. I take the point that usually in these cases, where the appeal has this general feel at the Court of Appeal stage, where we're looking more at the FTT decision than the UT decision. But let's not forget, the UT are the institutionally competent court or tribunal who are charged with assessing whether reasons are adequate.
Yeah. And
so I would not accept that they should be left out of the party altogether. We should definitely look at what they had to say and what they were invited to look at. So that's my agenda. So let's start off with the procedure at the hearing. Consolidated bundle, page 70, FTT decision, paragraph 14. Well, actually, even sorry, just to do it logically, even earlier. page 69, paragraph 10. So in my submission, Judge Roots does all he can to structure the proceedings before him. He identifies issues in dispute, and he's reached out. He's reached out to try and get help on this. Paragraph 11, he's actually exchanged emails with the parties and had something by way of response. Moving on to paragraph 70, his paragraph 13, he refers to the papers being a little bit unsatisfactory. But importantly, paragraph 14, here's the Home Office bundle. And he refers to the fact that the Home Office have, in October 2022, revisited the case, with obviously the fall of Kabul and developments like that have somewhat changed the backdrop again by way of which Afghan appeals are being assessed. And he summarises what they say in this letter. But as has been noted, I needn't dwell on it, 14b, on destitution, all we see is the possibility of accessing aid in Afghanistan. 14c, conclusive grounds positive trafficking decision is noted, but the implications aren't considered. So in terms of helping the judge explain why it was that a twice trafficked person going back to a country they hadn't lived in for more than a decade was not going to face difficulties, the Home Office had not really done very much before the hearing started. Also, paragraph 70, page 70, paragraph 17, Respondent's review. As we will see in a few moments when we look at the First-tier Tribunal's distinct procedures, Respondent's review has for some years, as part of, they call it the reform procedure, has been a critical part of how these appeals are conducted, especially from 2022, even more so more recently.
What happens under a review if it had taken place? It's a review of the experts' reports.
So the theory is that the so the first thing that happens is the Home Office send in their respondents bundle, which is their stuff, Home Office interview, screening interview, their refusal letter, anything else they happen to have, the deportation record, of course, in a case like this. Second stage is the appellant then puts together their bundle of evidence, expert report, and together an argument. Third stage is respondent's review, which is where the Home Office come back at the appellant's basic case as it's being put on appeal and say, oh, we agree with that bit and we don't agree with that bit. That would be the opportunity to raise issues of cross-examination if expert reports are going to be challenged. And that's it. Stage 4 is the hearing.
I'm sure what you tell us is true. Where does this come from? Is it from a practice direction or statement?
Yes, it's practice direction. I mean, the 22. So just to, well, I'll go to this now as I was saving it, but I'll go to it now. So, firstly, in my skeleton and in our bundle of authorities, we put in the wrong practice direction. We put in 2020-24.
This is something has arrived on our
exactly. So
yes.
we put in the 2022 one,
right,
which lays down this. This is the one that the Secretary of State, sorry, that the Tribunal was operating from. I'm going to come. I don't want to lose my place. Actually, I'm going to come to the authorities on this. But as you're asking me the question, let's.
It's all right. If you want to come to it later, then do.
Okay, but if you wouldn't mind, we will come back to it later. Otherwise,
I'm just thinking about how this was going on. I mean, we remember obviously. It was April 22 was the fall of Kabul.
August 2021, I believe.
August 21.
Yeah.
Right. Okay. So that was after the decision by a couple of years, and in turn a couple of years before the First-tier Tribunal. It fell between. It fell at the midpoint between the decision and the appeal.
Yes, that's right, obviously, but by the time the FTT determines its appeal, they're thoroughly in the swing of appeals being about post-fall of Kabul.
Yes.
But of course, some of the paperwork in front of them may not have caught up. Yes, procedural stage. Oh, yeah, so no respondent review, that's what I just said, page 70, paragraph 17 of the FTT decision. And then the actual submissions at the hearing. So, I mean, it's fair to say that the presenting officer doesn't make too much of an impression at the hearing. I believe he's actually called Mr. Ridgway, but he only gets called the Hoppo. So he adopts a relaxed stance at the hearing. You know, he's asked by Appellant's counsel, paragraph 29 of the decision, FTT decision, do you want to cross-examine a westernisation? No. Doesn't dispute westernisation. In fact, there was no cross-examination of the appellant. And as I'll come to in a moment, let's not forget, I mean, the appellant had put in a witness statement. He put in a detailed witness statement about his family circumstances. The expert had commented on his family circumstances. So this was important.
This is SB 164. We have it.
Yes, that's right, that's really be, yes. And then, paragraph 34, now so we've had the point at the hearing where live evidence is being taken, and in fact there's hardly anything, presumably, beyond adoption of the witness statement. And now at paragraph 34, Hoppo made very limited submission on the issue of westernisation. I'm not sure what the presenting officer did actually make submissions on, but it was obviously, you know, he took a fairly relaxed stance on this appeal in general. So that's the procedure in terms of what happened. Now, my second point is just to have a little look at the expert evidence that was in front of the tribunal, expert evidence and in fact witness statement evidence too.
Before we do that, I have paragraph 34 in front of me about the limited submissions made by the Hoppo. What is VSO? It was not such a degree he would face.
Oh yes, I see. Yes, so the immigration rules compartmentalise Article 8 ECHR into two stages. Stage 1 is very significant obstacles to integration. Stage 2 is everything else, like links in the UK, etc.
Right, yes. Right. Yes, experts report. It would be very helpful to me if at some stage you could look at the FTT judgment, paragraph 35J. Miss Phillips, who was then appearing, referred to various passages, but none of those page numbers have any tie-in to our bundles. And if you or Miss Sardar have the cross-references, I'd be very pleased to have them.
Of course, but I mean, remember, firstly, we've aimed to address that self-evident need in the skeleton, which in the replacement version does cross-reference what we think is important. Right. I'm not saying we've done it quite like that, but we've got close to it. Secondly, I'm about to refer you chapter and verse to our key bits. Right. Thirdly, absolutely no problem after the hearing, just sending in an annotated version of that page, because I see it's quite annoying in terms of how it's been presented so far. Thank you.
Right.
Because what's probably important to us is what the judge had in mind, not what you have in mind, in a sense. So that's.
I totally understand that. I'm not seeking to put thoughts into the judge's decision. I mean, I'm aiming to read between the lines, not write between them. But let's not forget, if the presenting officer says at the hearing, "Look, Judge, get on with it," it's not that surprising that the judge then, you know, it doesn't necessarily summarise in too much detail exactly what he's going to. So anyway, so the first point I wanted to look at was David Rigby, who said this is his February 2023 psych report. And he expresses his conclusions. So this is supplementary bundle, 53.
Thank you.
And just a general point on medical evidence in asylum appeals, but maybe in medical evidence in all legal proceedings. Although the Home Office skeleton, though perhaps less, they're all submissions, makes a lot of diagnosis, and they say all that's wrong with you is moderate PTSD and depression. Medical evidence doesn't only address diagnosis. Just as important is prognosis, and it's prognosis to which we now turn. So page 53, paragraph 22.5, headed prognosis. First paragraph, second sentence, stressful life events are a risk factor for deterioration in depressive symptoms and mental health. 22.52.
Sorry, could you just give the reference again?
So 22.51, page 53. supplementary bundle.
Was this referred to by the FTT judge?
I'd say it's referred to in a compressed way because he, paragraph 41, is paragraph 41. Given all the above findings and the unchallenged expert evidence, along with his particular vulnerabilities, health, and as a victim of trafficking. So trafficking is mainly Panjwani. Core conditions in Afghanistan is mainly Foxley. Westernisation is mainly Foxley. But health can only be Ripley, in my submission.
Is there any reference to Dr. Rigby at all? There's reference to Foxley and Panjwani.
No, well, there isn't. I mean, if I can get it in at all, it comes via health. If you don't think I can, then we'll skip on. But I mean, the country experts are writing their reports in the context of Mr. Safi's vulnerability, and his vulnerability had been expressed in terms of mental health issues.
The Rigby report seems to have fallen away because of paragraph 42. The judge said he didn't need to consider the Article 3 health, so he didn't do so. Is that where that fell out of the reading?
Not I understand it. I understand that health was front and centre to vulnerability, but the health point here is that there was no case being put that because of health, the appellant would suffer a collapse of his physical and mental health, such as to experience intense suffering or imminent death, the super famous Paposvili test. That's the concession that was being made. No one was saying that there's a vulnerable man with depression, PTSD, which the psych report said could worsen on a return. No one was saying that wasn't relevant to how he would be in the future in Afghanistan. And that, in my submission, is why the judge refers to health in paragraph 41. It's compressed. I mean,
It refers to medical evidence at 24. I thought that was the only reference.
Well, he says in at 24, he says he has mild depressive disorder and PTSD, and he says the medical evidence wasn't disputed at the hearing. I mean,
And then presumably that is reflected in the reference to vulnerability generally, and then in 41, health being a facet of vulnerability.
I mean, that's how I read it. And we have got the Skeleton argument at the very back end, the FTT Skeleton argument from the appellant, as then was Mr. Safi's Skeleton argument. And that has a whole page. Somehow it seems to fall out the pagination of the supplementary bundle, but it's the very last item. So its page number is ASA 7,
Yes.
medical report. So, I mean, the appellant, whereas the Home Office had forgone the opportunity of a respondent review, made virtually no submissions and not cross-examined, the appellant had provided a skeleton argument in which they summarised not only the report generally, but even the bit I'm talking about, paragraph 28 of the skeleton.
But again, Rigby is not mentioned. Rigby comes later.
I mean, my learned junior stresses to me the import of paragraph 24 of the decision here, when he's plainly, in my submission, the judge is plainly looking at medical conditions and noting depressive disorder and PTSD. So he is recognising vulnerability, and that can only be in the light of the reports.
So I've just caught up. When you said ASA 7, that's our page 252.
It's at the very end.
Yes, yes.
Yes, of course, I'm on paper, not PDF, so of course I didn't, yes. So, before the court is too eager to knock Rigby out of play because she didn't get a name check from the judge, I would emphasise that Mr. Safi's side had done everything they could to put her on the decision-making agenda, including a skeleton argument pre-hearing. So in my submission, it should be assumed the judge, who would be reading all the material in front of him and who is not to be lightly assumed to ignore stuff, would have been cognizant. That's my case on whether or not it was looked at. It should have been looked at or was looked at. So on the footing of that premise, back to supplementary bundle page 53, just to look at the rest of the prognosis. Page 53, 22.53, halfway down the page. Previous diagnosis of a depressive episode puts him at greater risk of further depressive episodes. In 50 to 85% of individuals with a single depressive episode will go on to experience a second depressive episode, etc. I mean, essentially painting a negative prognosis for people in Mr. Safi's position. Next paragraph, 22.5.4, previous traumatic experience, including trauma as a child, being the victim of rape, increases long-term risk of developing mental disorders, including further depressive episodes. And finally, and critically, going over the page at the bottom, within paragraph 22.5.6, in my opinion, his mental health is likely to deteriorate if he is removed from Afghanistan, including a deterioration in his depressive symptoms. So in my submission, and this was how, as I understand it, the advocate, Ms. Philps, had put the case before the First-tier Tribunal. The appellant would be more vulnerable, absolutely not suggesting he reached the Article 3 threshold for health alone, but he would be more vulnerable to problems in Afghanistan because his mental health would be in a state of decline.
To what problems?
Well, we would say it would make it more difficult for him to negotiate any of the issues identified by the experts, to which I'm going to come. But for example, westernisation, I mean, just to give you the answer in a sentence, westernisation, the issue is Taliban checkpoints. If moving around Afghanistan at all, you are likely to encounter Taliban checkpoints. And so if your mental health is fragile, that is going to be a worse experience than if it isn't. That's the headline submission, just to answer your observation. Anyway, if I can now move on to the experts who are definitely name-checked and more clearly referenced. Okay, so just to do it in the order that the pages appear, just to make it easier, I'm going to do westernisation first. We get some westernisation, page 113 of the supplementary bundle, paragraph 18. And this just fleshes out the answer that I just gave you on Taliban checkpoints. And the writer says, the risks of being stopped, questioned and searched would broadly...
Who is the writer? Mr. Foxley.
This is Foxley, yeah, this is Foxley. So as he puts it, penultimate sentence, paragraph 18, page 113, the risks of being stopped, questioned and searched would broadly apply across the country. Then, 115.23, I believe the greatest risk to your client will be in his home area, where his background is more likely to be remembered or re-established. Then his paragraph 24, paragraph? Bottom of 115. Your client is unlikely to know the exact political and security dynamics operating in his home area at the time of return, who dominates the village, who is spying, who can be trusted. Paragraph 25, if your client doesn't appear on 116, if your client does not appear to fit in, he's likely to be challenged and questioned. In small rural communities, he may well stand out in terms of clothing, dialect, local knowledge and attitude. So that's how he first addresses westernisation. Shortly he will come back to it, but just to keep going in order through the report. Then at 117, he emphasises the lack of family support network. He says that a robust extended family is generally seen as the vital support unit. And without one, you'd need NGO support, his paragraph 28. Now on a few pages, 126, he addresses accommodation. So this is part of the issues of vulnerability and possible destitution. 126, paragraph 40, he says finding safe and secure accommodation is a major challenge. Huge shortage of accommodation, he says. And this is important, this next bit. 127, 42 to 43. he emphasises that a large proportion of Kabul's population, at the bottom, well, 8% of the population, are either displaced by war or returnees who previously fled the country. IDPs in Kabul often settle in areas at the outskirts of the capital. Probably, he goes on to say, to reside in tents, mud brick and tarpaulin shelters. These settlements include some of the poorest and most vulnerable households in the city. And a few lines on, halfway down the paragraph, which starts page 128, he refers to the continuous fear of eviction and the danger of people being forced into secondary displacement, and negative coping strategies like, I'm not worried about child labour, but drug use addiction, reducing quantity and quality of food. So that was what he said about accommodation. Then on employment, 128 to 129, I mean, his theme basically is that there's a very, very high level of unemployment in Afghanistan. And once we get to page 130, his paragraph 46, he says there's no unemployment benefit per se, other than stealing, begging, and handouts from aid agencies and charities.
That doesn't make an Article 3 case, does it?
Well, my submission is when we get to what the FTT does with these series of possibilities, he accumulates them, and on the Article 3 anti-destitution point, he's entitled to do that in my submission. Arguably, it makes the anti-threshold. And if the Home Office didn't get a lot of reasons, well, that's because they didn't really refer to much country evidence of their own. And then he reverts to westernisation, and some of it's repetitive. We needn't worry about it. But the thing that is important, page 135, paragraph 53. He talks about the Taliban checkpoints again. He says he'd be much greater risk of adverse attention than an average Afghan citizen. Information could come through language, clothing, documents about his person, or on a mobile phone, or from his own witting or unwitting revelations whilst under questioning. So this isn't just talking about chance encounters with a fundamentalist shopkeeper who reports you on. It's about being actively stopped in the course of your daily life at checkpoints staffed by zealots. One cannot help but note as an aside that normally that the Home Office position on why it is that young Afghan men, fit young men as they so style them, are usually should be happy to return to Kabul in Afghanistan, is modern means of communication, because they can keep in touch with their friends in the West by phone or correspondence. Well, actually that mobile phone documents about your person the very kind of thing which elevate outright the possibility of outright harm. Anyway, he repeats, he makes the same point again and again. What final point on westernisation? 136, his paragraph.
Sorry, you might want, I don't know, to refer us to paragraph 54 on page 106, which is the result of such adverse attention.
Yes, indeed. I mean, at this point, spotlight it nicely. I was going to come to it when I was dealing with the FTT's reasoning, but just a headline point on this entire our defence of the appeal. The appellant wins, broadly speaking, on two grounds. He wins on westernisation threats, i.e. being questioned, illegally detained, suffering human rights abuses, torture, or suffering death. No anti-issue there. There's no issue about extension of Article 3, Papashvili. Not in play on that limb. But he also wins on destitution, which is the point where the FTT could possibly have tried a bit harder, one would have to acknowledge, though I would still maintain it's just about there in terms of adequacy of reasoning.
Well, anyway, you say that if he wins in the sense of establishing Article 3 barrier to removal, doesn't have to win on both.
Indeed. I only draw it out now just because it's, in a sense, a lot of the Home Office case throughout has proceeded on the basis of, you have to reason out this super high threshold. Not for being tortured and detained and possibly murdered at a checkpoint. You don't have to show a high threshold for that. Either it happens or it doesn't. Real risk of it happening is Suring, Article 3, not Papashvili, etc. Article 3. Right, so that's I feel I've given Foxley a pretty good outing. And now Panjwani. So Panjwani's a trafficking expert, and actually, I mean, I think really it was alighted upon during our learned friend submissions that I'm actually going to read from my skeleton for the first time, actually, because it's becoming useful. Paragraph 30 of my skeleton, I'll give a quote, which might be easier for you to find. Panjwani, his paragraph 11:14, based on my professional expertise, I conclude that Mr. Safi removed to Afghanistan, he would be at high risk of being re-trafficked. There are several indicators ranging from his young age, sexual abuse, route to Europe, and criminalisation that demonstrate he is a potential victim of trafficking. So it's quite clear what Panjwani's conclusion was on this issue. And the reason why he said it, if you want to look at his conclusion first, the reason why he said it,
Sorry, will you give me the paragraph in your skeleton again?
I'm sorry, yes, paragraph 30.
Thank you. Thank you.
Right, I'm just finding another reference. Oh yes, here's my other reference. So Panjwani, in his own report, so back into the supplementary bundle, page 78, this is where he joins the dots, evidentially, about why it is that someone like the appellant would be a risk of re-trafficking. So he has his own observations, and then he gives a long quote from a trafficking report, US State Department report, I believe. And halfway through that report, he identifies who's at particular risk of trafficking, or re-trafficking.
Sorry, which paragraph are you on now?
So this is page 78, headed 7.1, but we want the bottom paragraph, the second half of the page, starts since Taliban takeover.
Yes. Yeah.
Halfway through that paragraph, he adumbrates who is at risk: former members of the Afghan National Security Forces and others associated with the Ghazni government, internally displaced persons, forced deportees, voluntary refugee returnees, irregular migrants and refugees. So it means that somewhere within those categories is obviously going to fall Mr. Safi, who would be returning as, well, depending on how he goes, either a forced deportee or a voluntary deportee. So the conclusion, Panjwani's conclusion, I know he takes a long time to get there, but his conclusion is, in my submission, unsurprising. I mean, he's basically saying that this young man, who was sexually abused by another Afghan in Greece, equals grooming, and then more than one expert notes it, and even the sentencing judge was sympathetic, it will be remembered in the criminal trial, was groomed by a criminal gang and ended up, obviously sadly offending and being rightly punished by an appropriate sentence. So, and one might say you hardly need an expert to tell you that someone with those two historic incidents in their life and returning as someone who's going to be the bottom of the pile in Kabul or wherever else he ends up, a returnee with no family links and possible deteriorating mental health, is going to be in difficulties applying the ANTI test. So that's what I wanted to say about Panjwani. The only other thing I wanted to look at was the appellant's witness statement, which gets, I do know it gets short shrift in the decision, and Judge Root barely mentions it. But anyway, it's in this bundle we're looking at, supplementary bundle 164 onwards. And we've looked at the Home Office refusal letter very briefly earlier, and they said, well, you already told us about your parents being dead, but we're not impressed by that, essentially. But on this appeal, he turns up with a witness statement, which he's worked hard on. And 164 paragraph 2, he refers to his father being killed by the Taliban. Paragraph 4 on 164 again, he described in detail his father being shot and killed. His mother was killed. Sorry, I'm just looking for the reference about where he says his mother subsequently died. yeah, sorry, 169, paragraph 28. He says, I've experienced depression, I have feeling of sadness and troubling thoughts about my mother, who passed away in 2013. So so he said that his mother and father are not available, and therefore not a family support network, as to which Foxley had said was something of central importance to alleviate the prospect of destitution. And as we know, because we've looked at it repeatedly, Mr. Ridgway for the Home Office below just didn't challenge this witness statement. I mean, what happens if a witness comes to court, invites cross-examination, having put in a witness statement, saying their parents are dead? In my submission, whether or not the judge spells it out, there can only be one outcome to be inferred from the judge's approach, is that one aspect of Mr. Safi's vulnerability is the lack of parents. Now, of course, more engaged cross-examination, or any cross-examination, could have said all kinds of things, couldn't it? It could have said, what about your uncles, aunts? What about siblings? All kinds of things it might have gone into. But that didn't happen. And so there was no affirmative evidence to draw the inference that family support would be available. Okay, that's my little tour d'horizon of the expert evidence dealt with. Now, I want to move on to...
So there was no oral evidence before the FTT judge at all. The appellant was there, attended for cross-examination, and Oppo says, don't want to. Everybody else is in writing. Is that right?
Yes, that's it. Yes, I mean, when that happens in the First-tier Tribunal, when the understanding would surely be, if not in other courts as well, that the evidence was accepted. The evidence, the witness statement evidence was accepted. That's the only reasonable inference. So what is for now? So okay, we've done my first 2 points. Yeah, procedure at the hearing and expert and witness statement evidence. My third point is the findings in that context, and it does, I hope, bring them slightly alive. Let's not forget obviously you could structure this decision slightly better. Not normal to put the submissions in between findings and conclusions, but that's essentially a drafting style issue. Page 71, paragraph 28. He talks about the immigration history detention. He says, although there's limited information, it was not disputed he's been working part-time since then. So, part of the Home Office case has always been fit young man. As I say, that's pushing it in light of the medical evidence, but nevertheless, even taking fit young man at its highest, yes, the judge was completely aware of the fact that the appellant had a history of working. It's not a matter he overlooked. He put it in his findings. Then on westernisation, paragraph 29 onwards, obviously this sort of goes by concession, and the two key strands, though, 30 and 31, are been in the UK since December 2010, so this was June 2013, wasn't it? So 12 and a half years, which is virtually half the guy's life. 31, his evidence that he now speaks Pashto with, and obviously that should be accent, was not disputed. So they're two key factors of westernisation that the FTT alights on in terms of findings. And it then cites the CP in paragraph 32 for the general position about westernisation. Now, one point on this is that, the Home Office presenting officer below seems to have put his case very much on, look, westernisation is a thing that our CPIN goes on about and a thing that the experts mention, but whatever westernisation is, this appellant, Mr. Safi, does not have enough of it. But in the context of the Home Office's own published guidance to CPIN left westernised vague. So in my submission, it's hardly surprising that if they leave a concept vague, other forces will move in to populate it. Here, expert evidence plus judicial findings from the expert first instance tribunal. Then paragraph 33, well, Foxy and Panjwani get name checked. I've done it to death now. There was more that is impliedly inferentially accepted. Hoppo, no submissions on westernisation, no submissions on very much. Ms. Philps summarises various points. She makes the point that the applicant doesn't practice Islam, drinks alcohol, etc. So various westernisation features there.
If you were a judge of the tribunal and a hearing is upcoming tomorrow, later today, whatever it is, you may get a skeleton argument from the individual, such as we've seen. Is staying with the individual for the moment, is it expected that there will be some document? Are directions given for there to be some document of case?
Well, so remember by the chronology I gave earlier of the way the directions operate now in the reform procedure, the idea is that it's appellant, skeleton and bundle, then respondent review, then hearing. So there isn't anything else. You wouldn't expect anything to come at the last minute unless the appellant sees points taken in the
Right, so
respondent
it's not a clatter of skeleton arguments at the door of the court. That's not what you.
If the Home Office did a skeleton argument, it would be the first-tier tribunal would die of fright. I mean, it would never be. It wouldn't know what to do with it. It wouldn't even know what directory to put it in.
That was my ultimate question, which was whether one would expect to see any, I think, advocate's document at such a hearing. You wouldn't.
Not on a Home Office, but not, obviously on some kind of case they're taking seriously. They take some seriously. I mean, obviously sometimes if it was some kind of important case, Afghan hijacks, etc.
Country guidance case.
But yeah, but in a first-tier tribunal, normally it would be a surprise if the Hoppo did a skeleton argument.
Okay, thank you. Would they make reference to the decision letter, or is it just free-floating?
Well, the way it's presented to the judge, yeah, is that they get a thing. They call it the stitch bundle. It's like a thing which administrators put together, a massive long PDF of everything they find that the parties have put in. And the stitch bundle typically starts with a Home Office refusal letter, then has some notes by the tribunal administration, then has the first-tier tribunal, has the appeal form, then it has the appellant's bundle, then it has the respondent's bundle, then it has the respondent review. That's what it looks like geographically. So the judge getting a case is always going to I imagine he or she will turn up the refusal letter first and the respondent's review, because that combination will tell them the presenting officer's position in theory.
Thank you.
Was there in this case any sort of order for directions, or is that too grand a term?
Nothing. Nazada rightly reminds me, yes, there was paragraph 17 of the FTT decision, page 70. It was noted that directions had been given in April 23 for the respondent to review the document. So it wasn't even a case where the procedure is the standard one, where everyone's supposed to follow the practice direction, whether or not there's something specific. This is a case where specific direction to review had been given and still, sadly, did not eventuate.
If those directions exist in the document, Sardar, if you could lay your hands on it, I'd be glad to see it.
We will do that in our wrapping up point, so we can liaise with the other side if there's any mutual wrapping up to wrap up.
While we're looking at this page, could you just say a little bit more about what we might gain from paragraph 16? What's all that about?
They do that in abbreviations, don't they? Yeah. So SCA is single competent authority.
So
They're the
that's the
people.
trafficking.
So the trafficking people. Yeah. Well, OASIS. OASIS is the probation, usually the pre-sentencing probation report.
Right. So the SCA decision, December 2021, is what accepted as victim of trafficking.
I understand it. I mean, I must admit I haven't seen it. I understand it that it was very.
Expect is meant by that.
Yeah. Of course.
And then the probation report, 54 pages, and nobody referred to that.
I imagine that would be because Article 8 in the family life sense wasn't being pursued. The OASIS report and risk of reoffending didn't have any purchase on the appeal. So, and now we reach the FTT's reasoning. So page 73, paragraph 37. Firstly, impeccable direction on standard of proof. Yeah, there's absolutely no question here that standard of proof for Article 3 risk was appreciated. It's the real risk standard, the Surin standard. 38, I accept there's a risk of re-trafficking which would breach Article 3 given the NRM decision, effectively the trafficking decision and the expert evidence. And then he even refers to trafficking being on the increase in Afghanistan. No doubt that's from Panjwani. So in my submission, given the evidence available on re-trafficking, combined with the appellant's own history of double grooming and trafficking, that conclusion was open to the first-tier tribunal and wholly unsurprising. And that would be a violation of Article 3 ECHR in my submission. It would be inhuman or degrading treatment to be forced into prostitution or whatever else might be included within trafficking. Paragraph 39.
What was said against you, at least in writing, was that it doesn't follow that somebody who has had a terrible childhood, but who came to this country at age 15, was it 16? 15, is for that reason at risk of re-trafficking as an adult of 28 or 29 years old.
I understand that. I mean, I must admit, I took a little while joining the dots myself. I don't think Panjwani is saying that because the appellant has suffered sexual exploitation whilst in Greece, he's necessarily going to suffer a precise repetition of that form of abuse. But what he's getting at is that given that returnees are first in line for problems, that was the essence of the bit of his report that I took to you in terms of the evidence base, that conclusion is an unsurprising one. So the risk of re-trafficking is as a returnee who's been previously groomed is likely to be at risk of trafficking in my submission applying the Serving test. So that's trafficking. 40, destitution. Well, the judge refers to the appellant being a particular risk of destitution. He refers to the appellant's circumstances being in the context of general poverty. In my submission, he does not blindly align poverty and destitution. He says there are extreme difficulties in finding, he will have extreme difficulties in finding accommodation, healthcare and employment. And then cites the Ainty test. He gets the right bit of it very concisely. And then his paragraph 41, for all the same reasons, so he's now referring back to vulnerability and so forth in general. I find that given the appellant's particular vulnerabilities, health and as a victim of trafficking, he's at real risk of such material deprivation and destitution on return to Afghanistan, and also allow his appeal under Article 3 on those grounds. So in my submission, those findings, insofar as what we've seen so far, we're going to do a little bit of law in a moment briefly, were, in terms of how the case was run in front of Judge Roots, that was a perfectly reasonable disposition of the issues. And I now propose departing from Judge Roots, my next theme, my fourth theme, which is the legal context. So, duty to give reasons, I do want to look at that very, very briefly, and we can look at it via TC, so authorities bundle, page 305. So, no surprise here, classic authority, South Bucks versus Porter. Reason for decision must be intelligible and they must be adequate. They must enable the reader to understand why the matter was decided as it was and what conclusions were reached on the principal controversial issues, disclosing how any issue of law or fact was resolved. Reason can be briefly stated, the degree of particularity required depending entirely on the nature of the issues falling for decision. People cite that so much, we might almost forget what it actually says. It doesn't say there's a universal duty to give reasons that's at one level. It identifies, in my submission anyway, the duty to give reasons fluctuates with the degree of contention between the parties. Now, whatever one might have imagined before the hearing, in terms of whatever documents the Home Office might have put in, having forgone the opportunity to do respondent review, at the hearing, the presenting officer puts very little in issue. And so, you know, far from the classic, you know, locus classicus of reasoning being against us, in my submission, it's in our favour. It has a built-in safeguard about how hard the decision maker has to try when, depending on the issues that are disputed. So that's the general, you know, I found on that as a general point. While we're here, we'll jump into the the immigration and asylum chamber at all levels, its procedural architecture in terms of the practice directions which we mentioned earlier. So you see the bottom of the same page, 305, paragraph 26, final sentences. This tribunal panel, and this, remember, this is a super power. I mean, maybe it doesn't matter the constitution, but it is actually a rare and super powerful panel because it has the presidents of the FTT and the UT on it in order to kind of really lay down the law. Bottom of 305, the procedural architecture in the FTT, including the PS's practice statement, that's a 2022 document I've given you, under the reform process, is specifically designed to enable these principal controversial issues to be identified and for the parties' preparation, as well as a hearing to focus upon them. And then a bit later, same still as TC, page 313, paragraph 60. We see a citation from these two presidents of Lord Burroughs describing the 3 C's in a classic speech on judgment writing: clarity, coherence, and conciseness. So, you know, let's not forget, conciseness is an objective. It can be a friend as well as a foe. Clarity and coherence will be best achieved through the identification of the principal controversial issues. Sentence on, the practice statement is designed to ensure the procedural architecture is in place to ensure that legal principles governing the quality and content of determinations are satisfied. So it's in this context of the procedural architecture of the First-tier Tribunal that what actually happened below falls to be assessed. There is a massive enjoinder on the parties to engage early and before the hearing in the identification of issues and to make it absolutely clear what they want decided. And what's the classic thing on judicial seminars? They always say that reasons are for the loser. You're writing reasons for the loser. The Home Office could be under no illusion as to why it lost this appeal if it simply looked at the expert evidence. And it's unsurprising if it didn't invite or challenge that evidence. It's unsurprising that it received the conclusion that it did.
I don't think that the FTT decision in this case is a very good advert for the application of paragraph 61 TC. They say that in that case, the FTT quoted verbatim from the relevant reports, sentencing remarks, without identifying and summarising the main evidence relevant to the issue. This led to an inadequately reasoned decision on the issue, despite a very lengthy decision. They seem to be saying that it's no good quoting at length from experts' reports, or, I would add by way of gloss, simply referring to them, without saying what you get from them and why it is important to what is in issue.
I mean, no one would dispute that this decision could have been followed. But the question is whether or not it reaches the minimum standard of legal adequacy. So in my submission here, Judge Roots has done enough, given the stance taken by the presenting officer, which was not to direct him to anything troublesome. Well, and there's another point on the expert reports. Let's not forget that these experts are under the same duty as are nearly all civil experts, no doubt, not only to give their opinion, but where they have a range of opinion on a particular issue, to give their range. you've seen that conclusions of each report. There was no range of opinion expressed by any of these experts. If you were on board with the expert at all, there was only one direction of travel in my submission.
Yes.
Okay, so that's the legal, that's the legal milieu that we're in. And then my final point, though not in fact the least of my points, is the pursuit of the appeal to the upper tribunal.
Yes.
And obviously it is to be regretted, no doubt, on the part of the government that my learned friend Mr. Keith wasn't on board to make his lucid points rather sooner. But the fact is, they are rather saddled with how they pursued the appeal below. So we've seen what they did in the FTT, so let's see what they did in the UT. So to start off with, let's find their grounds from FTT to UT, page 64. Remember, we know why they've lost because we've all been reading the decision all morning. They come up with two grounds. The first ground, page 64, paragraphs 2 and 3, is headed reasons, and indeed introduced reasons. But I would question whether or not this in truth was a reasons challenge as opposed to a rationality challenge, because what we then get is no citation of authority on, what level of reasoning we should have received. They just raise factors. They say, spent early years in the country, retains a knowledge of Pashto. Further submitted, the appellant has family and therefore the potential of a supportive network. The appellant is an adult in good health. In fact, if this was a judicial review with the duty of candour, you might say that those points are pushing it in terms of how much of the Home Office, how much of what had really happened in the FTT is revealed in that paragraph. But there you are. That was, that's how the refusal letter might have perceived things going into the appeal, but it's not how the factual findings came out of the process. Anyway, paragraph 3, they say they recite in international aid. But in my submission, by reciting a series of their favourite bits of the evidence, they're not really criticising the reasons. They're saying there was only one way of deciding the appeal, in favour of our evidence. I mean, that's how it could well be construed. Anyway, at least they were broadly on target in terms of the destitution issue there, I suppose. I mean, notice too, ground 2, the test at which they directed themselves was reintegration, i.e., which we did mention earlier. Reintegration is the Immigration Rule Article 8 test, which the judge referred to as VSO for very significant obstacles of integration at one point. They don't even target the Article 3 test in ground 1, not clearly. Ground 2 is quite remarkable, I would suggest, because what they quote in ground 2 is not anything about westernisation, re-trafficking, etc. It's about what they sort of call the security situation, i.e., are civilians in danger from the war? Are they in danger from airstrikes, armed crashes, detonations of IEDs, assassinations? Well, they might have been, obviously not. This is years after the fall of Kabul. So, as an agenda, and let's not forget, the grounds of appeal are an agenda on which the upper tribunal could reasonably operate. This is a pretty unpromising agenda. Anyway, there you are. As it happens, they got into the upper tribunal on the back of it. So what did the upper tribunal make of it? Their decision is page 53 onwards, but where it matters, page 54 and 55. I mean, again, of course, no doubt the constitution of any particular UTI doesn't really matter, but I do mention it's a High Court judge and a specialist full-time UTJ, so it's quite a good combination of wisdom, you might think. Anyway, their reasoning, also compressed, page 54, paragraph 7. It is quite plain from the decision that he allowed the claimant's appeal because of a particular case-specific combination of reasons. There was no one factor that was determinative, but a mixture of his vulnerability, his history of having been trafficked, his lack of ability to adjust to the country because of his westernisation, the particular risks he would face. So anyway, UTARC had no problem in putting the judge's reasoning in an efficient little pot. There, paragraph 9, ground 2 we find really adds nothing. I mean, I'm not surprised they say that, given the critique I just made of it. Paragraph 10, ground 1 does give us some concern. We understand why permission was granted. So obviously they do see it as a reasons challenge. And they say, you know, the judge hasn't given the full reasons. They say paragraph 11, he's acknowledged the background evidence, referred to it by page numbers, doesn't explain in great detail what evidence he relied on. Paragraph 12, their conclusion, and in my submission, this is correctly applying the tests for judicial restraint in reviewing first-tier decisions. He's done quite sufficient to explain his decision. It's clear to a fair-minded reader that the judge has accepted the expert evidence, accepted the claimant would face a variety of risks for the reasons given, and concluded that cumulatively there was at least a real risk the claimant would not be able to re-establish himself, so that even his life would be at risk. So, and then they give the Judge Root some homework that he might want to think a bit more about his structure in the future. And they do stress at paragraph 14, the point I'm drumming home, the lack of cross-examination and challenge on the part of the presenting officer. You know, these judges too are astute to be aware, no doubt, of the decisions from the upper tribunal about how procedural rigour is very important. So I highlighted this submission earlier. I mean, I wouldn't, whilst I am of course aware that in general, in cases of this nature, the court tends to jump straight to the first tier decision and decide if it's adequate or not. In my submission, where the whole case is about were the reasons adequate, you should also have appropriate respect to UTAYC, who are institutionally competent and expert. They do it for a living, of reviewing decisions and deciding if the Home Office tried hard enough to get a fully reasoned decision. That is fully within UTAYC's expertise. And here, of course, although no doubt the second appeals test has been hurdled, you are an appellate court, which must give, should give appropriate respect to UTAYC in my submission, bearing in mind the institutional setup of the entire system. So I've now said an awful lot, if not everything, of what I really wanted to say. Checking my overall notes. So headline point is that the duty to give reasons modulates with the fervour with which the parties put their cases, and here it was a one-sided battle. A final headline point, yes, is that the Home Office could not have won this case in my submission in terms of how they put it. We can all kinds of questions in cross-examination we could imagine about how ill does going to Afghanistan make you feel. Have any of your friends gathering wood on the Helmand hillside recently moved to Kabul and set up a business and might support you? All kinds of lines of inquiry that might have been were not pursued. So remittal here would really be used use the duty to give reasons as a Trojan horse for giving the Secretary of State a second bite of the cherry, because this case could only be won with much more sophisticated and energetic cross-examination and submission. And that is a fundamental point of appellate principle, I would at least propose, that all judges should be aware of at all times, and the Home Office should not get that second time round. That's everything, unless I can help you further. That's everything from our side. Thank you.
Thank you very much, Mr. Symes. Ms. Sardell? Thank you. Mr. Keith?
I don't think I have anything to add in response unless there's anything I can assist with.
Thank you. Do you have any questions? Right. Thank you all very much. You have been very concise. No one could criticise you on that ground. We're very grateful to you. Ms. Sardell, if we could have, in the course of the day, the cross-references, page numbers in 35J of the FTT decision. There was one other thing we asked for, I can't remember what it was.
The directions.
Oh yes, the directions
We've
given
located
in or about April or May 2023 by the FTT, we'd be very grateful. We will reserve judgment. We'll send out a draft in the usual way. As counsel well know, the draft is sent out not for re-argument, but for correction of typos, obvious factual errors, dates and so forth. And the contents of the draft are confidential to the parties, including obviously the respondent and those who need to know in the Home Office until formal promulgation by publication on the National Archive and so forth. Thank you all very much.
Court rise if able.